Our firm represents many clients who have very low blood alcohol concentration readings when they're charged with impaired driving. This happens all the time where someone has a reading in the 80s. Now, if you have a reading in the 80s, that means your reading gets rounded down at the absolute minimum 80. That's the legal limit. If you're charged with 80 or over, you're going to get charged with over 80 B.A.C, blood alcohol concentration. The first question they often ask me, which is a very loaded question, difficult question to answer, but I'm going to answer it. Are my chances of winning a DUI charge, that is an over 80 charge, 80 plus B.A.C charge, better if my readings are low? The very technically correct answer to that question is this: it shouldn't be, because as a lawyer, you're looking for mistakes that the police made, charter issues, search and seizure issues, whether the police dotted their I's and crossed all their T's. And very technically, whether your readings are high or low, it shouldn't matter. But what happens when you go to court on a close case? So the judge knows those readings are low. And if the judge on a close call case sees they could go this way or that way, guilty or not guilty, they're going to tend to bend over backwards if they can pick a lane if you got very low readings, because it almost seems unfair in a way that you're rated 80. By the way, 80 used to be you won, but they changed the law recently. So that's the answer. It's a bit of a loaded question, but psychologically, it does affect judges convicting people on readings of low readings. But there has to be a defense. It's not like the judge is going to make one up. But if they can pick a lane, maybe that lower reading will help them, assist them in picking the lane that's right for you and is going to win your case.